Good afternoon, everyone. You're all very welcome to our webinar on commercial contracts, What's Market. My name is Edel Hartog. I'm a partner in MHC's commercial contracts team, and I'm joined today by my partner and colleague, Wendy Hederman. Hi, Wendy. So today we're going to look at the themes of what's market in commercial contracts, and a huge amount of the work that Wendy and I do involves the drafting and negotiation of all forms of commercial contracts. And that spans very many industries. So it could be tech or financial services or the public sector. And I think what that gives us is a really good sense of what's market or what's norm, or what are the trends or the negotiating parameters for some of the key issues that you'll commonly see in commercial contracts negotiations. So today we'll hope to share some of that market experience with you. Wendy, over to you on our agenda for today.
Thank you, Adele. So for the past few years, we in the commercial contracts team in Mason Hayes have been tracking the main clauses in a wide range of contracts. You know, whether it's a software license or a framework purchase agreement or distribution agreement or an outsourcing, there are a handful of clauses that generally give rise to the most tricky negotiations. And with our database of these common legal clauses, we've been keeping track of what's agreed in particular transactions, particular sectors. We have a bank of clauses to deal with special cases, and it's allowed us to spot trends and how these issues are tackled in practice. So with this MHC What's Market tracker, we're able to advise our clients if they ask, is it reasonable for us to have to give an indemnity in this circumstance, or what's the usual position in Ireland on amounts of caps, etc. And we then went about complementing that Mason Hayes tracker with a survey of in-house counsel, asking you what your experience is, what your practice is, and so we throw the net wider and get a more accurate picture of what's been used in the market. So I want to thank all of those who responded to what was our second What's Market survey. We had an even bigger response this year. It's given us a really good set of data, which we're going to share with you today, which I hope you'll find useful and give you a really good picture of what's out there in the market. The areas that we're going to discuss, those of you who responded to the survey won't be surprised that the areas we're hitting on are liability caps, types of cap, the level or quantum of caps, carve-outs from the caps, so uncapped liability, and or super caps or lower caps, so special cases. We then turn to indemnities, which we know is an increasingly tricky area. And we're going to look at a couple of sort of still topical issues like force majeure in the context of COVID-19, Brexit, good faith obligations in B2B contracts, e-signatures, and that through that we'll be outlining to you some of the trends, and we'll hit a few more of them towards the end of the webinar. And you can ask questions during the webinar, which we'll endeavour to answer as many of them as possible towards the end. If you could use the Q&A function there in the bottom of your screen, put your question in there and we'll do our best to answer it. So Adele, back to you for our first topic.
Okay, so I think what we might look at first is three of the metrics that inform the survey data we're going to talk about today. So you'll see these on the screen. So on the far left, you'll see the percentage of our respondents who either identified as a supplier or as a customer. So you'll see about 44% of our respondents to the survey identified as a customer and 56% identified as a supplier. And so a reminder that the data and the trends that we're talking about today relate to B2B or business to business contracts. So we're not going to discuss B2C or business to consumer contracts, which have a whole other array of issues to discuss. You'll see in the center the types of industries that responded to our survey and that are represented in the What's Market data we're looking at today. You'll see our highest responses, for example, were from technology at 25% and from the FS or financial services industries at around 20%. But you'll see a nice mix across that table showing the types of industries that are represented in our survey. On the far right-hand side, you'll see the split between the public and private sector. So you'll see about 80% of our respondents were from the private sector and 20% from the public sector. And we'll come back to public sector contracting a bit more later. what we saw in the survey responses were some quite interesting comments asking about the public sector approach to contracting and the public sector approach to liability allocation in certain cases. So we'll touch on that later in terms of that public-private sector split and their approach to contracting. So if we kick off first on the first issue, and that's liability issues or liability caps. And if you do put in a cap, what's the quantum or what's the multiple of your cap that you would apply? So we asked you, do you routinely include liability caps in your commercial contracts? And you'll see here the answer in the middle is the highest percentage. So you'll see about 50% of customers and 46% of supplier respondents indicated that yes, they do routinely include a cap, but not a mutual cap. So a cap to protect their own interests only. So this is kind of reflective of how, in-house template contracts might be drafted. So they might start out on each case with a cap, but not necessarily a mutual cap. If we look then at which of the following approaches to caps do you most commonly apply, you'll see, for example, that the response is unsurprising from the supplier's perspective, and the data or the percentages are pretty consistent with the survey we carried out in 2020. So you'll see about 36% of respondents who were suppliers said that they would typically cap their liability at the total contract value, whereas about 29% of respondents said that they would cap it at the annual fee. And that's pretty normal. That's consistent with what we're seeing from the supplier side in the market. When you look at it from the customer perspective, the responses are not surprising. Naturally, customers will want the opening position or the opening gambit to be higher. So you'll see about 39% of customers indicated that they would cap their liability at a multiple of the contract value, or they would cap it at a fixed monetary amount. So for example, €100,000. And that would be pretty typical, that we would see customers drafting their contract, setting the liability cap at a higher level than the contract value. What we might often see is a hybrid of both of these circles you see on this screen. So for example, if you have a contract where at the outset of the contract, the value of it may not be known because the orders or the demands or the drawdowns under the contract may not be fixed, then what you might have is a hybrid of both of these. So you might say, for example, the limit of liability is capped at either, or the higher of, more likely the higher of, a multiple of the contract value and 500,000, 5 million, for example. So you would typically often have a hybrid as well in terms of how you would describe your liability cap. We then asked you, so we know it's normal and it's market for there routinely to be liability caps. We asked you, where you typically agree a cap as a multiple of the contract fee, which multiples do you typically use? And the response is pretty consistent with the 2020 survey data. You'll see here about 52% of suppliers and 52% of respondents identifying as customers said that they would typically or routinely cap liability in contract at 1 to 2 times the contract value. And that would be pretty, market standard. Very often we get the question, are there different multiples for different markets or different industries? And there can be some quirks, but broadly speaking, a 1 to 2 times multiple would be pretty normal in a contract negotiation. What's interesting about this data when you compare it to 2020 is that we have a dilution of the percentages in the 1 to 2 bracket. So we have a reduction of those percentage, but we have a higher percentage on the right. So we have a higher percentage of respondents who indicated that routinely or typically the liability would be capped at 3 to 4 times contract value or 5 times or greater. And that's interesting because it's reflecting 2 themes that came through in the survey data or in the free text responses where our respondents were able to indicate their comments or other comments or identify the trends that they're seeing. The first trend is that many of you indicated that you were seeing a more aggressive approach to contracting or you were seeing a more defensive approach to contracting. And, that equates and is typical with, higher liability caps being asked, for example, of a supplier in a contract negotiation. The other theme was that many of you expressed, I suppose, an interest or a question about how the public sector contracts and why it appears that the liability caps or the liability posture or the standard of liability or responsibility in public sector contracts tends to be higher. And that is correct. That's my experience. I suppose I'm a commercial contracts lawyer, but I'm also a public procurement lawyer. And so what I would often see is, a template form or an agreed form of contract issued with the tender documents. And typically, oftentimes, the opening position may be that there is no liability cap in the contract, or there is a relatively high liability cap. I've seen one, for example, in the past couple of weeks where the liability cap was set at 500% of the contract value. Now, that's an outlier. But I suppose it is indicative of the fact that the public sector would typically tend towards the higher level of the liability caps. And there's a number of reasons for this. I suppose one is that, a breach of a public sector contract can have a disproportionately high impact on numbers. So a whole portion of the general public is affected by this breach of contract. Or for example, in a professional services contract, the advices may disproportionately impact, the shaping of public policy in a particular area. So the stakes are very high for the public sector of a breach of contract or a fallout from their contract being breached. And I think nowhere have we seen that more currently or recently than in the HSE cybersecurity attack. So the stakes are quite high for breach of a public sector contract in terms of the magnitude of people that may be affected by it. The flip side of that also is that in most instances, the public sector will be subject to a competitive tendering obligation. So they will tender their contracts on a competitive tendering exercise. And I suppose oftentimes that means it's a take it or leave it. This is the contract and you bid on the basis of the contract that comes with the tender. And I think then there needs to be an understanding between, the private sector who are tendering on that contract and need to understand, that's the deal for this project. And oftentimes there's a little wriggle room for the public sector to negotiate a change to that liability cap at the later stages of a procurement procedure. But also, I think there's an acceptance on the public sector side that if the private sector introduces a risk premium for a higher liability cap, then the public sector may consequently see higher bids and higher tender costs. So I think obviously, the survey data is showing that in terms of the approach and the understanding of the public sector contracting approach being slightly higher in terms of liability caps or perhaps the quantum of liability. Wendy, over to you next for special caps and carve-outs. You're on mute, Wendy.
Story of Zoom. Yeah. We also asked you about exceptions to the standard contract cap. And, in our experience in the survey, it's clear that there's a more layer and nuanced approach to caps. It's not a case of one cap fits all. We've heard from Adele that about 85 to 90% of contracts routinely include caps. And what we're looking at now is what are the exceptions or other caps or uncapped liabilities that are commonly in contracts. So we show the data here for whether you apply a separate cap lower, higher or uncapped across 6 main buckets of breach or types of incident. And this slide takes the supplier responses first. My next slide in green is on customer. So the first type of breach we asked about was for GDPR, next confidentiality, etc. So that first string there shows you that breaches of DP obligations, suppliers are having to give a higher cap pretty much all the time. It's either higher or uncapped liability. The second one there, breach of confidentiality, that's when you take the higher cap with the uncapped. You talk about 85 to 90% of the time. And then again on third-party infringements, IP infringements, that's pretty high, generally uncapped liability 70% of the time. I should say very briefly, not all these numbers add up to 100%. And yes, you might say that's because lawyers aren't very good at maths, but actually it's because we gave respondents the option to tick more than one box. So not only did they tick more than one of the 6, they actually put in answers. So treat these as sort of order of magnitude, not as absolutely accurate in terms of percentages. So how does this compare to 2020? Well, the first 3 buckets are pretty similar to last year's response. But what you might note on the indemnities, there on the right-hand side of the screen at 60%, this is a notable increase this year in 2021. In 2020, a higher cap or uncapped came to 45%, now it's 80%. And that actually is an interesting aspect of a theme that we're going to look at again in relation to indemnities. And in my view, that's a very high proportion that you've responded looking for uncapped liabilities on indemnities. If we turn to the next slide, which is on the customer side, you can see that customers expect higher or uncapped liabilities for each of data protection, first bucket, confidentiality, and IPR infringements, those first three red circles. That's pretty high, but also if you look at the final bucket, general indemnities, that's coming in at nearly 90%, though more in the higher cap than in the uncapped columns. And as for how this compares with 2020, well, customers looked for uncapped liability across all 6 buckets more often in 2020. So whether it's a question of a move in the market or just people responding this time, what the survey data indicates is that even from the customer side, more customers are prepared to engage with or to work with a higher cap rather than an uncapped liability. And I think probably from our perspective in negotiations, particularly on data protection GDPR breaches, there is a real reluctance to give uncapped liability, and often a higher cap will actually get you the contract, over the line. If we turn to the next slide, which is actually looking at the GDPR breaches more particularly. So we asked, do you concede as a supplier or ask for uncapped liability for GDPR breaches? And these are in yes, always, yes, but only in certain cases, and no, we don't. You can see that as suppliers, 36% will accept uncapped liability either always, that's 18%, or sometimes. And the same proportion, the 36% will accept a higher cap. So that means that the numbers of you that are saying that you won't accept uncapped or higher liability at any time is less than a third. So at 28%, that's down a fair bit. It's actually down a bit on last year, indicating that, suppliers are kind of pushed to agree higher or uncapped liability all the time or sometimes. And on the right-hand side, the customer perspective, a higher proportion will always, 52%, look for uncapped liability, or 13% in sensitive cases. Only a small proportion, 6%, say they look for a higher cap instead of uncapped liability. So there's a bit of a disconnect between customer's perspective and supplier perspective in this. But interestingly, the trend from 2020, sorry, I'm bombarding with stats, the trend from 2020 is that the proportion of customers who aren't demanding an uncapped liability has increased. There's a little more acceptance on the customer side that they're not going to demand or get uncapped liability. And I think probably this is, indicative of just parties, customer and supplier sides getting used to negotiation. And also what I found is in certain industries, customers realizing that, okay, if we said out at the beginning that we require a really high cap, a high level of liability on GDPR breaches, that will get the contract agreed instead of sticking to a position of uncapped liability.
Yeah, I think Wendy, we're seeing that as well in the survey responses, where we got very many comments on GDPR, liability caps for GDPR, indemnities for GDPR. So really it is a big issue that still, even post GDPR now, a couple of years post it, the market is still settling in terms of the negotiating stance and what we're seeing. So I think that kind of move towards the middle a little piece is very welcome. Yeah.
Okay. So we wrap up on next slide on caps. So, what is the market? Well, our experience is that it's a layered, nuanced approach to caps. And often it is the way to get a contract agreed is to not keep fighting on the one standard contract cap. It's to take them, as I say, kind of bucket by bucket. And in a lot of organizations, it's easier to agree to uncapped liability, let's say confidentiality and IP breaches, but then as long as the caps for other areas are lower. There is still a difference, not surprisingly, in expectation on the customer and the supplier side as to what should have a higher cap or uncapped. GDPR, as Del mentioned, the battle lines and the expectations, while still some gap between each side, they're moving and evolving a little bit. And I think what we've found in our practice is that this idea of setting out expectations on extensive liability, and often it is, linked to what insurance a supplier can get or has already in place. You set out those expectations early in the process. It can definitely, I would say, smooth things. It means it doesn't hold it up at the end. Okay, I think we should move to to indemnities. Indemnities can definitely be tricky in many contracts. There's a fair degree of consistency in the data on what type of indemnities are likely to be in a B2B contract. We asked you, what types of indemnities are you likely to give or to require? And you'll see on the left-hand side there, the first one that we asked about was data protection. Big expectation on the customer side. You probably guessed by now, all the green bars are indicating of customer responses. 73% of customers expecting an indemnity for GP breaches. Pretty consistent on both sides, 85 and 82% on third-party IPR infringements, and then lower figures for the other sample indemnities that we mentioned in our survey. And actually, except for the property damage will not be relevant to a lot of contracts. And same thing with 2P. I mean, in a contract and outsourcing where there's a potential for transfer of employees, it's very standard that there will be 2P indemnities, and often the expectation will be that if you're demanding one on exit, that you get one on entry. But 2P isn't going to be relevant to all kinds of contracts either. But on indemnities, this was a theme that came through very clearly from our, I think we move to the next slide, from our respondents. Just to give you a couple of the direct quotes, members of our audience said things like, we are seeing counterparties increasingly looking for indemnities for breach and not just for third-party claims. Requests to or agreeing to be liable on an indemnity basis for any liability arising under contract. And a third comment was very broad indemnities covering any breach of contract. So we thought we'd just pause for a moment and look at what's the difference between an indemnity and a breach of contract claim. An indemnity is a promise by one party to pay money to the other on the occurrence of a specific event. It's to, reimburse them on a euro for euro basis for money that the other party, the indemnified party, has lost or paid out. And in indemnity claim, it's the trigger event that's really important. And traditionally, the trigger event would not be breach of contract. It would be things like a tax bill coming in or somebody suing me for something. The trigger event, it's often a third party making a claim against the indemnified party. And, like our audience, we have seen an increasing request or trend towards indemnifying, not even just for all breach of contract, but for all loss we may suffer arising out of any act or omission of the indemnifying party. And that, really cuts across contract law principles of breach of contract. Irish common law contract principles are pretty well evolved through case law and statute by way of, well, what's a breach of contract, causation, what types of damage are recoverable, reasonably foreseeable, this whole issue of direct losses, economic losses, and an indemnity, it's a different legal concept. And in my view, we really should be resisting this idea of indemnifying for all breaches of contract, because it just sidesteps and puts out the window the traditional notions that people have in entering into contract as to, well, what damages, what losses will they be liable for? So really, it's to watch very carefully, what's the trigger event in the indemnity? And I have to say, we do find that when we negotiate and really tease out and work through with the counterparty as to, well, what's the purpose of the indemnity versus what's the way of pursuing a breach of contract remedy, generally can get to a position where parties are a little more comfortable.
Yeah, I agree with you there, Wendy, as well. Oftentimes, the feeling is, I haven't done a good job unless I've gotten an indemnity, or the customer approaches, I need an indemnity. But I think you're right that it's a special animal. It's a special type of protection, and that indemnity for breach of contract isn't something that one would typically ordinarily always ask for. It's a huge win if you get it, but it isn't something that would be typical or normal or reasonable in many cases to ask for.
Yeah. Yeah, we should probably, I did say earlier that, they require very careful drafting. And there is a case, most people put it up there, from 2017 from the UK, where the UK Supreme Court looked very carefully at the wording of the indemnities to do with customer complaints or claims to the FSA, it was to do with an insurance case. And the courts said, well, what we're being asked to do here is to look at exactly what the trigger event is. What wording do the parties use? Because it's a B2B contract, it's up to them to put what they want in. And they construed it, if you like, more narrowly than the plaintiff wanted. The court didn't include, or didn't accept that the indemnity covered the company itself making a complaint to the FSA. It was only third-party customer claims to the FSA. And, it is a lesson that an indemnity is very much a construct of contract. So be careful how you word it. And that second last bullet point I have on the slide there is about how do indemnities interact with the caps. It's not always clear. You've got certain wording in your liability clause, and then you've got somewhere else an indemnity. It's not clear if one caps the other. And, you can sometimes, by taking the wording of one or the other, to have a fair guess at whether the indemnity is capped or not. But really, much better not to be in a position of having to guess if it does. Make it really clear. Negotiate it up front. Okay. I think, Adele, we pass to you on enforcement.
Yep, back to me on force majeure. So I suppose we were really interested to see, we're 15 months into COVID, and we wanted to see what the survey data was showing us in terms of the impact of COVID on the drafting of force majeure clauses. And what we wanted to see particularly was whether there was a change in the data from when we asked this question in 2020 to the data we're seeing now. And the answer is yes, there is an uptick in the response to this question. So we asked, have you revised your standard force majeure clause as a result of the COVID-19 pandemic and related restrictions? And from a supplier perspective, 65% of the respondents indicated that yes, they have changed their force majeure clause, and 60% of customers said that they have. Where we're seeing that manifest is in a real surgical attention to the drafting of the force majeure clause. So for example, your force majeure clause may now specify pandemic as a relief event, or it may specify restrictions due to the spread or possible spread of disease, or it could specify, for example, restrictions arising from local regulatory or government restrictions. And so that could, for example, relate to restrictions on business opening or recommendations, for example, on business closures as a result of COVID. We also asked, have you had to consider seeking relief under a force majeure clause in light of COVID-19 restrictions? And the data here again is slightly higher than what we received in 2020. So you'll see on the supplier side, 24% of suppliers indicated that yes, they asked for relief because of COVID-19 under their contracts, and they got it. And 8% indicated that they asked for relief but didn't get it, which I thought was an interesting statistic. On the customer side of things, 35% of customers indicated that yes, their suppliers asked them for relief and they gave it, whereas 10% didn't give it, whereas 10% of customers said that yes, they were asked for relief and they gave it. So you'll see a small minority of customers indicating that yes, they gave relief. And oftentimes it will depend on the drafting of the force majeure clause, or often what we're seeing is there's a negotiated outcome because of the significance of a particular supplier or a customer relationship, that there may be a negotiated outcome in a given case. What we were interested to see as well was what type of relief did you get or give, for example, as part of COVID-19 fallout. And you'll see here by far the highest percentage was that 83% of customer respondents and 63% of supplier respondents indicated that the relief that was granted over the past year or so was predominantly in the form of an extension of time under the contract. And that makes sense in terms of delayed deliveries, for example. You'll see on the right-hand side, the next nearest, roughly the next nearest, was a price increase or a price decrease, so a price change. So for example, suppliers indicated 45% of them indicated that the relief they got was a price change. Or the other highest percentage would be a temporary suspension, for example, of obligations under the contract. So I suppose, what does this all mean for force majeure, and what's market for force majeure? I think what we're certainly seeing in our practice and what's coming through in the survey data is a kind of a more settled approach 1 year on. I think there's an acceptance that COVID-19 isn't necessarily, or the disruptions of COVID-19 aren't necessarily an outlier. They're not a singular event in the sense that we can expect or possibly estimate that there will be resurgences, seasonal resurgence, variant spikes, or new successors of COVID in the future. And so I think what we're seeing is an acceptance that the force majeure clause needs to come out of the dusty boilerplate and coming more towards the center in terms of negotiations, particularly in supply chain contracts where the effects of business interruptions or supply chain can be disproportionately impacted by events like COVID-19. So what we're seeing is force majeure coming into the center as one of those items that gets bespoke attention in every contract, in most contracts. The next thing that I think what we're seeing as what market is a continued focus on the clarity of the wording of a force majeure clause. Case law and the Irish courts have been very clear. There is no settled or commonly understood meaning in law of what force majeure means. It means what you say it means, or it means what you draft for it. And so that means you can't expect, or you can't assume, that the dusty contract in the drawer has a force majeure clause and therefore it's going to cover us. Because the courts will say, what does your force majeure clause in this instance mean? And if I give you an example of where there's commonly deviations, and these are unrelated to COVID-19. Often in a supplier contract, labour disputes or industrial disputes or lockouts will be included as a force majeure event for the supplier, whereas in a customer drafted contract, that will either not feature at all in the force majeure clause or it'll be strongly resisted. So again, I suppose, the takeaway is that there can't really be an expectation that the force majeure clause will rescue a given situation, because it doesn't really need to be drafted for the bespoke circumstances. I think that the third trend, or things, or what we can expect in the market, is that I think we're going to see a lot more case law or litigation falling out of COVID-19 in the coming years. You'll see on the slide, I've just touched on 3 of the very recent cases in the market on this. And I think we can, and I'm sure there are many more, and we can expect many more. We'll see, for example, in the Irish market, 2021 in February, we had the Publicans FPD insurance case involving very high profile probs like the Leopardstown Inn and Sinnets. And there were similar cases in the UK with the FCA versus Arch Insurance. Now, these were insurance cases and they are their own animals, but what we can see in those cases is the court forensically going into the drafting to see, did your drafting address the circumstances that you're getting relief from? And there could be no expectation or assumption that your drafting always achieves X result if it's not pretty clear and crisp on the circumstance. The last case in the slide I thought was quite interesting. So anyone who's in M&A or in the corporate sphere may be interested to see this, and that's the Travelport case. And in that scenario, the court looked at what a material adverse effect was in a share purchase agreement, which was a clause allowing for get out from the purchase to proceed in the event that COVID-19 had a particular material adverse effect on a certain industry. And again, the court came in with its zoom lens and looked at the drafting of the material adverse effect clause to see whether COVID-19 or other circumstances were appropriate for relief.
Adele, before we move on from force majeure, I'm often reminded in a supplier contract once that I was negotiating where the supplier was to provide emergency services, on-site ambulance, on-site fire, on-site chemical protection for a manufacturing plant, and they were the services that this supplier was to provide. There was also a force majeure clause in that contract which said, oh, we'll be excused from performance in the event of a fire, a flood, a leak. And quite clearly, so it's very much, it should not be a case of boilerplate. That's a very extreme example, but the force majeure clause can be quite central to what service it is that's been provided. In a lot of outsourcing contracts, you'd find that.
Yeah.
Whether, force majeure should relieve them entirely of their obligations, or whether actually it should mean that they're only relieved if they've worked through the disaster recovery and business continuity plan.
I agree, and that would be my first port of call, which is what's the clause dealing with BCD, business continuity and disaster recovery, and does that kick in first before the other reliefs? But that's definitely a cautionary tale, Wendy, in terms of checking the force majeure clauses for a bespoke deal. We might move next to Brexit. Is it still relevant? And don't roll your eyes. I know many of us have complete Brexit fatigue, but for the pointy-headed commercial contracts drafters, it still is relevant, and we are seeing it continue to be relevant in our practice. And so we asked you in your contracting arrangements, how often is Brexit a consideration for your organisation? And we saw a higher percentage response this year to when we asked the question in 2020. About 80% of customers and 24% of suppliers indicated that, yes, sometimes Brexit is a relevant consideration in their contracting arrangements. And I suppose, you know, in the first 3 or 4 months of this year, where we had the big freeze following Brexit, and we had border delays and customs delays and disruption, many people had to go to their contracts and see, actually, is this a relief event? Is it not? What are the circumstances or the consequences of these types of delays arising from Brexit on their particular contract? I think the second question is one that, you know, may be with us for some time, and it's probably the big elephant in the room, and that's jurisdiction. So we asked you, when contracting with international counterparts, how would you approach a contract given to you that's governed by the law of England and Wales? And you'll see here that, roughly speaking, in the middle, you'll have 37% of customers and 33% of suppliers indicate that they would insist on Irish law and jurisdiction. And certainly that's our practice. You know, we're Irish lawyers, and certainly we would recommend that. But what's interesting in the data is we have a slight shift in the numbers to the right, which is suggesting that many of you, 37% of customers and 24% of suppliers, are more comfortable or getting more comfortable with accepting English law and jurisdiction, but you'll do that only if you adapt your contract for things like data protection, data transfers, and other issues. So I think what we'll see, and it'll be interesting to see how the market develops, whether it stays towards the centre, which is insist on Irish law, or moves to an acceptance of English law, but with very bespoke adaptations. And so I suppose, what's market then in terms of Brexit? Naturally, as I mentioned, we would recommend that contracts are governed by Irish law for a number of reasons. But if you are faced with a contract that's governed by UK law, there are a number of issues to consider. And the ones on the screen just, you know, touch the surface. But the common ones are, for example, you need to consider data protection issues. So the UK is no longer a member of the EU. Transfers of data to the UK in effect amount to a cross-border or third country data transfer. Provisions have been made to the 30th of June this year for transitional arrangements to apply or to continue to apply in terms of the safe harbour transfer of data to the UK, but we're fast approaching that time. We had expected, obviously, an adequacy decision in terms of the UK's data protection protections, but again, political commentary recently from MEPs in the European Commission suggests that that's far from a straightforward road. So whereas we had expected an adequacy decision mid-year, now looking possibly towards the end of the year. So what we need to look at is watch the space in terms of, if you have a contract with the UK or a UK counterparty, which will involve a transfer of data to the UK, watch out and take appropriate protections. The other issues will be, how does your contract address compliance with law and change in law obligations? And this is probably more relevant for medium to long-term contracts rather than maybe a 12-month contract. But outsourcing contracts, for example, would typically be on the longer side. You know, we don't expect English law to deviate from EU or Irish law very materially in the short term, but there may be a drift, and we can expect a drift over time. So what happens, for example, if your contract says someone has to comply with TUPE on the way out, for example, which TUPE law applies? Or what happens if your contract says you have to comply with health and safety under EU law versus what it may transpire to be under UK law? The other issues on the screen I've mentioned already. So ensure that your contract addresses things like delay. What if deliveries are delayed because of customs or border checks? Who bears the cost of customs duties? What happens if your contract is denominated in sterling or euro and there's a currency fluctuation? Who bears that exchange risk, for example? The other issue that, like jurisdiction, I mentioned earlier, I think is going to be with us for quite some time, is the issue of how do we tackle the enforcement and recognition of judgments in terms of the UK law. So, you know, as UK is no longer a member of the European Union, the Brussels I recast convention does not apply, which allowed for this very easily mutual recognition and enforcement of judgments. Now, post-Brexit, the UK is looking to the Hague Convention and is looking to accede to the Lugano Convention. Recent suggestions are that the European Commission are not minded to assist that accession to the Lugano Convention. I won't go into any further detail, but again, it's something that I think is going to be with us for quite a while, which is how do you enforce a contract that's governed by the laws of the UK and subject to UK jurisdiction when the UK is no longer subject to many of the mutual recognition treaties that are currently in place. Wendy, back to you on good faith obligations.
Okay, Adele, thank you. We asked this question of good faith because the law in Ireland and the UK has been moving and shifting a little bit on this topic in recent years. And so to look firstly at the survey results, we asked, did you include or accept obligations to act in good faith or to carry out your obligations in good faith? And I split that by supplier and customer. I mean, a fairly large proportion, so the yes generally, on the left-hand side, the blue, is 30%. And on the supplier side, 20%. That's a decent enough proportion zone, but when you add it to the yes, but only in specific circumstances, you actually get that it is the majority of contracts that would, in certain instances, have a good faith obligation. It's only about a third of in-house counsel that said we would never have an express obligation to act in good faith in our contract. So in a way, that's a little bit ahead of the courts, because if we go to the next slide, you know that in Irish law, there's no implied duty of good faith. And I've said except because a couple of minor things like commercial agents regulations where principal and agent both obliged to act in good faith. Even maybe you could call the platform regulations, another B2B contract. We're actually starting to import notions of fair dealing and transparency between platforms and traders. And I suppose that Irish position does contrast with the the continental jurisdictions like France and Switzerland, which have it expressly in their code that all commercial contracting parties must act in good faith, and also the US, though I don't know the full extent of it in the US, but I understand that where you are within scope of the Uniform Commercial Code provisions 1203, that obligation of good faith can't be waived by the parties. So the story in Ireland, it was very similar to the UK, but as you may all be aware, in the Bates and Post Office decision in 2019, the English High Court found that there is an implied duty of good faith where it is a relational contract, and that case is still, or the broader sort of dispute there is still making headlines in the UK, because it's to do with the implementation of a new IT system called Horizon across post offices in the UK, and about 550 sub-postmasters sued the post office because the Horizon system just didn't work, and several of the postmasters were criminally prosecuted for money which actually went missing because the IT system couldn't track it. And this year, the criminal convictions, many of them were set aside, and there were senior level resignations and stuff. But the case itself on good faith is quite interesting, and the UK courts have set out, you know, what's a relational contract and what does it mean then when the implied duty of good faith is implied into the contract. In Ireland, the position is we don't, as yet, have an implied duty of good faith. And I say as yet because in that Flynn-Breccia case, the judges definitely left open the possibility. The door is a little bit ajar. Both Justice Finlay Gagan and Justice Hogan accepted that there isn't an objection in principle to an implied obligation of good faith, and I suppose they're just waiting for the right case to come along. I just put the last case there is the only one since we touched on this topic last year, and it is that in the UK, the court there determined that not all relational contracts will automatically lead to an implied obligation of good faith. So it's almost a two-step test. Is it a relational contract? And then are the circumstances of that such that the party is expected to imply an obligation of good faith? If you move, Adele, to the next slide. I think express obligations good faith are common enough in Irish law contracts. As we said, a third of you would, from time to time, or in some contracts, have an obligation of good faith. Just to be aware of what does that mean in the contract in terms of your performance. If you look to some of the case law, you can see that it means, refraining from commercially unacceptable behaviour or acting in the spirit of the contract. And I suppose it's worthwhile for organisations to be aware what it will mean for them, including if you're thinking of terminating the contract, because I wouldn't be surprised if in a long-term contract you enter into now, by the time there's you get to the end of it and there's a dispute, you could be 3 to 5 years' time that you're in the Irish courts. And, as we've seen, it may well be that at that stage, the courts would be implying in duty of good faith in a relational long-term contract where the parties are very much dependent on cooperation with each other and there's a spirit of partnership, etc. So I think it will be, it is worthwhile for lawyers when they're drafting contract to think about good faith and to either expressly include it, and most often it's going to be expressly included. You then get to the discussion of, well, is this a mutual obligation of both parties going to act in good faith? Or you're going to have one party refusing to act in good faith, but expecting that the other party is going to, and that's kind of a curious negotiation. Or in fact, are you going to expressly exclude an obligation to act in good faith on both sides? So just a few things there to think about.
Yeah, I agree with you. I'd rather know than have it landed on me in 3 or 4 years later. So I think I am starting to see it quite often, and oftentimes in public sector contracts, albeit that they tend to come in because all the parties have to act reasonably and have to act in good faith. And so you'd very often see it there as well. But I'm seeing it as well in B2B kind of private sector contracts as well. But I think, I agree with you. We either say it applies or we say that there is no express implication that it does.
Okay, I think, Adele, that brings us to
final topic,
e-signatures.
E-signatures. Look, we included this because I think happily over the past year, what we've seen is that many of our clients are taking up the use of e-signatures, and that's from our perspective a really good progression. So we asked the question and we said, how frequently does your organization use electronic signatures to execute contracts? And the statistics were probably about the same, but maybe a bit higher than last year, which was suppliers indicate 50% of you will always use electronic signatures, and for customers it's about 43%, and then you move sideways into the sometimes. So between the always and the sometimes bracket, you have a very high percentage of respondents indicating that yes, you would now use electronic signatures to execute your contracts. We asked what type of electronic signature would you accept in a transaction, and again here you'll see the high majority of the respondents indicated that they would use a signature, or they would accept a signature using a third-party platform like a DocuSign or Adobe Sign or some other trusted third-party platform. And that's consistent with what we're seeing as well. Excuse me, that is what we would expect when we are contracting and using an electronic signature process. We would expect to see it using a trusted third-party signature platform. You'll see here, interestingly, on the left-hand side, many of you indicated that they would accept a scanned handwritten signature. Now, again, circumstances will vary, the risk profile of the contract will vary, the degree of trust between the parties will vary depending on whether you would accept a scanned handwritten signature in a given case over, for example, the additional security protections that a digital identity or a digital signature may give you in terms of warranting against hacking or fraud or other types of corruption of a signature. I won't go into the law on e-signatures. MHC has done a number of presentations and podcasts on e-signatures, which we've put on the screen, which hopefully you may find helpful. But what I will say is that, as a reminder for those of you who are new to the area of e-signatures, the law on e-signatures has not changed in the past year or so, but there have been important evolving legal practice guides. And I suppose that the big impetus for that was the March 2020 Law Society of Ireland's guidance note on e-signatures. And that, I think, gave the Irish legal market certainly more comfort with the use of e-signatures more routinely for the execution of commercial contracts. So what's market on e-signatures? I think that the trend we're seeing is towards the use of e-signature platforms, and particularly using two-factor authentication. So for example, that may be that the signatory excuse me, confirms their identity by email, and then they obviously get an SMS PIN code that they type in as well. So that's two-factor authentication. It's no more than you do for your electronic banking or for your online shopping. And so a similar process like that can be facilitated by DocuSign and Adobe Sign. And that's certainly our recommendation for how you would use these platforms. In terms of what's market more generally, the law on e-signatures, or I suppose the practice on e-signatures, and particularly what type of e-signatures you would accept, is evolving. You'll see, different practitioners, different academics, different law firms take a different approach to what type of e-signatures they may accept in a given transaction. The tricky issues are things like sealing, witnessing, and deeds. Those will continue to be tricky, I expect, for the next couple of years until the market and the law settles on this particular area. So if we move then very finally, just to wrap up and discuss some of the trends that we've seen in our survey and across the data. I suppose the first thing that you've seen throughout the slides that we've discussed today is that the data and our own practice is seeing a continued or an increased focus on data protection, information security, cyber security, and things like indemnities, uncapped liability, and high degree of negotiation of these particular issues. So there's a high sensitivity in the survey respondents who say, this is, a headache to us and it's on our desk pretty frequently in the commercial contracting sphere. Wendy, maybe over to you.
Yeah, I think I'll add on that point. Certainly negotiations on data protection, liabilities and GDPR are tricky. And I think sometimes it's worth sort of reminding or getting the parties to look at, how real is the data protection risk? What are the measures that have been taken? What's the extent to which data processing is a core activity? What the sensitivity levels are? And certainly if it is a contract where there's a lot of data and data transfer, data processing involved, it's going to take a lot of hammer out. But a lot of times data protection almost seems to be an issue because everybody thinks that we must have full coverage in GDPR. Yeah. What are the buckets of data? Can we minimize? You know what I mean? There are other ways of coming at it. But certainly, yes, it is a trend and it's tricky. The second trend that I wanted to mention was the extent to which regulation and sector-specific regulation is impacting contracts. I mean, in that context, data protection agenda are very much influenced by and almost dictated by what's in law, i.e. Article 28 GDPR, what you must have, what you can have, what you can't have in your contract. I suppose it's sort of similar thing we're seeing very much in the last couple of years for example, outsourcing contracts in the financial services sector. So whether that's CBI, Central Bank of Ireland, or European banking guidelines on outsourcing, or in the insurance, the IOPA, which is equivalent. These would apply not to just your sort of what you would consider your big standard outsourcing, but a lot of services agreements and supply and IT and process, and effectively requiring you to put certain things into those contracts that you're flowing down obligations so that there are audit rights and there's reporting and you can't change short notice. So the way regulation is impacting what you can or must have in your contract, and same thing in other areas like medical devices, pharmaceuticals, cosmetics. Quite a few of the agreements we're doing are very much dictated by whether that's appointing a responsible person or the fact that an importer has certain duties when acting for a non-EEA based manufacturer of a medical device. And yes, that's definitely a trend. And other areas of regulation that are also coming through into contracts, not new, but AML, anti-corruption, bribery, and things like anti-slavery, which are not really a matter of Irish law, but feed through into contracts because of global supply chains. On broader indemnities, we've touched, I think, on that quite a bit. It definitely came through in the comments from our and this trend for requiring indemnities for all losses, all breach of contract. And I hope we've given you a few sort of our views and tips on those. Do you want to take the next one, Adele?
Yeah, I might take the next one, which is the linking caps to insurance levels. And we got a number of questions from that actually in the survey responses, and questions, were we seeing it? And questions indicating that the respondents were seeing it more. I suppose my response on that is I would approach this with caution. I think if you're going to link your liability cap to the insurance level, you need to be very clear what that linkage is. So are you linking it to the quantum of the insurance level, or are you linking it to the coverage of the insurance level? And what happens if that particular insurance isn't commonly available in the market in that given year? What happens if, for example, the supplier didn't take out that insurance in that given year? What does that mean? Does it mean there's no liability cap, or does it mean what? So I suppose if I were to link caps to the insurance levels, and I do see it, I don't necessarily see it in any particular industry more than others, but I would be very cautious to make sure my drafting is very clear about what it is I'm linking. You know, for example, we'd often see contracts that says a contract that is attempting to limit the liability by reference to the insurance level by saying, subject to clause X, which is the insurance clause, all liability under this contract is limited to 5 million. But what does that mean? So are you limiting your liability by reference to the insurance clause? You can guesstimate that that's your case, but you know, it's not hugely clear. So yes, it's done. Yes, we've seen it done. Should it be done right? Yes, and I think I would approach it with a lot of caution. It would actually cost me more in drafting the clarity and all of the linkages and what it does mean and what it doesn't mean than were I simply to say the liability is capped at X or Y. But that's certainly a question that we've seen.
So I'm going to pop in there to say to you, one of the questions we have in the Q&A box is, what's the legal effect of setting out insurance cover, brackets for information only, in a limitations clause? Why do suppliers do it? Should liability caps be linked to insurance cover? On the first of those, what's the legal effect? Just mentioning an insurance, or just mentioning that a supplier has a certain level of insurance, does not of itself cap that supplier's liability. And
absolutely not.
Sometimes I've seen that, you know, professional services where they say, oh, I have, we commit to having professional indemnity insurance of 5 million. And the supplier thinks that that means that their liability is thereby capped, which of course it's not, because that only says what insurance you have. It doesn't say.
That's a contractual obligation, yeah, rather than a cap.
Yeah. Then in other parts of this question, why do suppliers do it? Should liability capping with insurance cover? When acting for a customer, I'm very wary to link it to having insurance cover. Like whether the supplier has and continues to have certain insurance cover is really a matter for them. As a customer, you can agree to cap the supplier's liability at a particular figure or in particular instances. But I'm really wary about, from the customer side, allowing that the supplier's liability is subject to them having, which is effectively what you're doing if you're saying it's linked to the insurance cover. You're saying, okay, we're only liable if we've got insurance for it. And as a customer, you don't want to be taking on the risk that your supplier does or doesn't have insurance. That might be on my question.
Yeah, I agree. I wouldn't accept that particular one, because I think your cap should be reflective of, it's kind of like the damages cases. It should be a reasonable estimation of your likely loss from the contract. That doesn't necessarily mean that that's the same value as the commonly accepted insurance cover in the market. So 6.5 million, 13.5 million. So I agree with you. I wouldn't necessarily think that it's an automatic connection between the cap and the value of the cap relative to insurance. The final point, we won't go over this again, but again, what we are seeing is a trend of questioning the public sector approach and possibly it having a higher or more onerous liability posture than might be typical in, for example, two commercial private sector entities negotiating contracts between them. So I think that's it for us today. Wendy, will we have a look and see, are there other questions? How are we for time? You know, will we look and see, are there one or two other questions?
Certainly. Well, there's one easy one here for me. What's a relational contract when it's at home? Helpfully, the Bates versus the Post Office decision did set out what is a relational contract. And in fact, in the Irish case, they looked at it as well, because it was to do with the kind of long-term arrangements between the shareholders for Blackrock Clinic. But the one Bates in the Post Office, there are a couple of criteria there. A long-term contract with a mutual intention of long-term relationship. The parties must intend that their respective roles be performed with integrity. Contract will involve a high degree of communication, cooperation, predictable performance, etc. So, you know, quite helpful points in the Bates decision, and I can see who it is that's said that question to me. So as soon as I'm not at risk of knocking myself out of Zoom, I'll read those points to that questioner and send them on to him. Okay.
I might take the next one, Wendy, because I see one here. So in public sector contracts, do you see suppliers trying to change or negotiate the contracts after the RFT stage, i.e. after the template contract has been published? Yes, absolutely, yes, I see it. but whether that's permissible or not depends on the type of procurement procedure that's being carried out. So the public sector are subject to very rigid rules in how they carry out their public tendering or competitive tendering processes. In the open and restricted procedure, there is little or very little room for the public sector to change or negotiate their contracts after the initial stages of the request for tender. In the negotiated procedure, there's a bit more flexibility for that. So I think, you know, the public sector can be restrained in certain of the types of public tendering procedures in allowing there to be negotiation at the RFT stage. And for the very reason that it's unfair for the public sector to set out to tender and say, this is our liability position, and people tender on that basis, but then the winner gets to kind of change this, and I prefer that, and I do X, Y, Z. So yes, I see it. Yes, I see it very commonly being asked, but I see the public sector equally being very restricted in the ability to concede or accede to some of those requests.
Okay, thank you. We've another question there. Just a good one. In cases where a customer seeks an unlimited indemnity for GDPR or breach confidentiality obligations and the supplier won't or can't agree, what do you see as the most common compromise? Is it simply just a higher cap for the test claim, or is it something else? And from my perspective, I suppose I've seen contracts where the extent of liability for GDPR data breaches was really important to the client, as in the customer was in financial services sector with a lot of financial data. And, you know, they had flagged that, so it was really important to them that it wasn't going to ask for approval without a really high cap. It still took a good bit of negotiation. And yes, it was a question of going for that higher cap. In other instances, I've seen that where the supplier has a real difficulty with what's being requested, I've seen that the parties have actually changed the way in which data is handled, and that their data didn't absolutely need to be given to the supplier, and they could work on the basis of only sampled data, anonymized data, that, you know, they sort of use that a practical or technical workaround. And I have seen other cases where suppliers will walk away because they don't want to put their company at risk of having unlimited liability for GDPR breaches, or be on the hook for something higher than they either want to get the insurance for or can afford the insurance for. I don't know, Adele, do you have any other compromises?
No, I agree. I think that's probably the ones that I'm most commonly seeing as well. The compromise that most often I would see is a higher cap. And then what is that, or what's the quantum of that, is the tricky thing, because it can't be so excessively high that it's kind of equivalent to uncapped liability. But equally, from the customer's perspective, they need to be secure relative to the volume of potential fines for a GDPR breach. Will we take maybe one or two more questions? I think we're just maybe one more question. What would you recommend if an organization's template contracts do not expressly provide for specific liability caps? And I might take that one. I mean, you know, the answer is it depends on the type of contract, and it depends on the exposure of the supplier under the contract or the customer, if there isn't a liability cap in it. What I would certainly say is that if it's your template and if you're contracting as a supplier, it would be very exceptional for it not to include an opening gambit, which is, oh, liability of the supplier is capped at X. Where I often see this come up as well, so I see it in negotiations, and caps are often hotly negotiated, but where I often see this coming up as well is in a corporate due diligence exercise. So if the entity is being acquired and the investor or the acquirer is doing due diligence on the contracts, uncapped liability is one of the red flag items. It's a red flag reporting item. So if your acquirer is saying this entity has 100 contracts under which liability is uncapped, so the quantum of exposure under it isn't necessarily quantifiable, that is a red flag item. Not necessarily insurmountable. It can be addressed by warranties or indemnities or otherwise, but it is one of those issues that stands out.
I'm just going to add that on the flip side of that, I've had a couple of instances where a customer has actually chosen not to put a cap, not to mention liability caps in their standard terms of purchase or standard contract of purchase, because they're kind of hoping that, okay, they know that their own liability is fairly, you know, they don't know a whole lot to do except buy these goods. And the debate, the discussion was, but if we put in any sort of mention of liability or liability caps on our own liability, then the supplier is going to go, hey, I
Of course.
have liability cap too. So actually, we left it out entirely on the assumption that that would mean that more often than not, we'd end up in a position with suppliers where they had no liability caps. So
yeah, you and I wouldn't fall for that though, Wendy. But exactly. I think we'll leave it there, guys. Thank you so much for attending the webinar today. It's been our pleasure to speak with you. Please do contact, or please don't hesitate to contact Wendy or I if you have any questions on any of the items that we've been discussing today. At the end of this, a pop-up survey will appear. It'll automatically appear on your screen, asking you to comment on the webinar today or to give some suggestions for what you'd like us to see discussed in the future. So thank you from us both, and please do contact us should we help you in the future.
thanks,
Thank you.